Good afternoon. It's a pleasure for me that I stand before these distinguished IP minds, experts, senior lawyers, and distinguished panelists here. I'll not hold you for long. I'll try to make it very small and short. Let us just, to start with, I get to, as part of my professional work, I get to deal with a lot of FDIs, foreign direct investors, that are interested to invest in Bangladesh. And one common worry or query or question that we've been facing from them over the last 3-4 years, that if we come and do business in Bangladesh, then how do we enforce our IP rights, or how do we protect our IP rights, and how effective is the IP regime in Bangladesh? So that is a common question that we face. So on this note, I felt that giving a little bit of background and sharing the latest developments that has been happening over the last few years in Bangladesh will leave you with some sort of knowledge and information if you have a client, or if you have business in Bangladesh, and if you are having IPA challenges, then it will help you to find ways in Bangladesh. So let's start with the IP legal framework. We have this Trademark Act, which is relatively new from 2009. Copyright Act, which was enacted in 2000. Patent and Designs Act, it's really ancient. And it's actually the law we used to share during the colonial period, and we still have that. There's a draft law, and the government is taking ages to enact the draft new patent law. We have had a GI Act from 2013, and so these are the statutes. And you'd be very pleased to know that most of these laws, more than 80%, I would say, have been taken from Indian law. So there is a lot of similarity, a lot of common areas between the laws of Bangladesh and India. In terms of the international treaties, we are a member of TRIPS. We are a member of Bern Convention, Paris Convention. We are yet to be a member of Madrid Protocol and PCT. The government is considering them, and maybe this year we might become a member of Madrid Protocol. With regard to the IP offices, we have 2 different IP offices functioning under 2 different ministries. One is DPDT, Department of Patent, Designs and Trademarks, which deals with the industrial IPs. The other one is Copyright Office, which handles the non-industrial IP. But one interesting thing here, that we also have an anti-piracy task force, which functions under the Ministry of Cultural Affairs. And this task force actually, based on complaints, they run raids and then file cases. So I'll elaborate on these on the later slides. Challenges that we found to have an effective IPO regime in Bangladesh is mostly lack of awareness among the stakeholders. And these stakeholders, not only the users, but also the creative fraternity, including the musicians, the software developers, and also the innovators, entrepreneurs, business leaders, and also the policymakers. Then among the administrators and judiciary also found that they actually lack the IP sensitivity, because often they do not really understand what is important in order to make policies which will help establish a effective IPO regime. And they do, we've seen previously, like back in 2010 and 11, even from the judiciary, passing orders that are in conflict of the existing intellectual property laws of Bangladesh. So there is lack of sensitivity and lack of awareness in our country. And this actually resulted in less enforcement efforts of IP in Bangladesh. Now, over the last 3 years, there has been radical change, actually. And this is very positive, and it actually leaves us to think that we are, in fact, progressing towards having effective intellectual property regime in Bangladesh. To start with, This is one of the encouraging stories in Bangladesh. I myself, with some of my colleagues, lawyers, and some of my clients, we take great interest in this area. And we thought that if we can have not-for-profit entities working on the human rights side, working on the child rights side, working on the women rights, working on water, to spread education on how to save waters and environment, then why not intellectual property? So based on that, in 2011, we felt that we should form a not-for-profit entity that can actually engage with stakeholders, including governments and policymakers, to take this IP initiative forward and do activities for creating mass awareness and also build capacity among the stakeholders. So, and then we established Bangladesh Copyright and Industrial Property Forum, which actually does activities for IP awareness and capacity building, which includes arranging seminars, workshops, trainings. It also publishes online IP-centric magazine, which is called intellect.com.bd. In 2013, it establishes an IP law clinic, which is a legal aid center that gives pro bono legal support to budding entrepreneurs, software developers, musicians, journalists, photographers, artists. And until end of 2014, this IP clinic has served more than 152 people. It also works with the youth, and which is called VIP, Volunteer for IP. It creates volunteers who actually gets basic IP training, and then they have a mandate to go and spread the IP news among their friends, families, and work associates. So it has started in 2014, so it's in 2015. So in 2 years, it trains 100 young students or youths on the day of World Intellectual Property Day, as part of celebrating World Intellectual Property Day, trains 100 youths every year. So by now, we've got 200 graduates, so another 100 will be coming this year and years to follow. It also works with industry, different industry, film industries, software industries, associations, and also music fraternity and similar industries in Bangladesh. So at part of it, I think I've got the wrong slide, missing one slide. Anyway, as part of this, we have been able to form the first ever CMO, which is Collective Management Organization, from the copyright front in 2014. And I'd like to thank WIPO and IP Office UK for this, because they actually invited us, WIPO and IP Office UK, to go to UK in 2012, and they trained us on how to form CMOs, Collective Management Organization, which actually collects, issues license for music use and collects royalties against those licenses issued by them. So, so then we are trained on how CMOs work. They took us through all the CMOs that are functioning in UK, and actually gave us a real insight into that. And then it was onus us to form it, and we finally got the license for one of the CMOs, first ever, in 2014. Now another one is in the pipeline, so maybe in the middle of this 2016 we'll get it. So once these CMOs are functioning properly, then the violation of copyright in the music industry will lessen. We expect to see less violations in the copyright area. In terms of other developments, we've had several raids. The developments, actually, I have divided them into 3 classes: raids, litigations, and settlements. So raids, we've had retail raids. Okay, raids are very common in India and other parts of the world, but in Bangladesh, actually, raids, we've relatively seen happening raids from 2014, actually. And in 2014, we had retail raids, and in 2015, we've also seen corporate raids. And I'd like to thank two of big technology giants, Microsoft Corp and Samsung, for this, because these two companies, they really have taken a 360-degree approach. They have gone to the policymakers, they picked judges, picked police officers, and trained them on the importance of IP, and then conducted raids, and then filed cases, and also we now have examples where we've settled cases, disputes out of court. Then on the litigation front, there is a Samsung case I would like to talk about. Samsung last year filed quite a few cases against parallel importers, and these are civil suits based on Trademark Act, started from the district court, and also filed a mandamus at the High Court of Bangladesh. To this extent, actually, we were very successful in convincing the Samsung senior counsels who traveled from all the way from India to Bangladesh that let's file a mandamus order. Because what we've seen, filing civil suits for trademark infringements at the district court and winning them after a long battle, because they keep coming to the High Court, then appellate division. And even if we win the cases at from the appellate division, these parallel importers, they will maybe to some extent stop importing these or come under an agreement with this brand owner, but still we've seen they are importing. They do not stop, because they actually, there is, we do not really need to say there are unethical practices at the customs. So they keep importing them. So this is why we felt, okay, let's have an order from the High Court based on some legal grounds, and which actually will make the customs officials to stop this and stop and confiscate these parallel imported products at the import stage. And we were very successful in making them understand this and also convincing them. And then we went for it, and we were successful in getting the High Court order. And then these parallel importers, along with the customs officers, they actually went to the Attorney General's office and convinced them to file an appeal at the appellate division against the mandamus order. And there again, the Honorable Chief Justice of Bangladesh, he dismissed the appeal in 1 minute, only asking one question, that I'll hear this matter. If you can tell us how the Attorney General's office of the government is prejudiced by the High Court order. And they could not give any convincible answer, so the appeal was dismissed. And the mandamus order, which is onus, which is actually a direction to the Customs Authority, to BTRC, who is the regulator of Bangladesh, of the telecom industry, and the Home Office, Home Department, which is our, the police, law enforcement agencies, they're part of it. It's a direction on them to stop, confiscate all the parallel imported items into Bangladesh. And based on these, actually, Samsung has had so many raids. And this has actually helped Bangladesh to earn a lot of, to actually increase the revenues, earning revenues. So this is one good example that we've had recently. Then there is a Microsoft case. We had a big raid last year. It's one of the largest hardware, like computer and laptop suppliers to the government. And this guy actually, he's been supplying laptops to most of the ministries. And these laptops are actually being supplied under a project of World Bank. And World Bank, when he won the bid, World Bank actually does not pay to the government directly. They pay to the vendor. So they, being the vendor, they took the money for, for the price of the original license of each laptop. But they ended up, once they got the money, they ended up not paying it to Microsoft for the license of the softwares they supplied to the government. So on this note, so Microsoft actually decided to go against this guy, and we raided him. We involved RAB, police, and the anti-piracy task force, and we raided the head office, and we found 70 laptops with pirated softwares, Microsoft softwares. And there was a high official arrested. He later on got released on bail though. Then this company, which is called
we need to wind up because
Sorry.
You're already up.
Okay, 2 minutes.
To the
2 minutes. Okay. So now, then they actually were forced to settle this matter out of court. And this is a unique example for Bangladesh and the first one ever that we've settled outside court. I think I've discussed all this, so I'll skip it. Now this is very interesting. In 2014, February, we've had a PIL filed at the High Court with, by some interesting, one interested lawyer who actually relied, we have a law from, we have an ordinance from 1987, which says that government should or must implement use of Bengali language everywhere. So based on that, he filed a PIL at the High Court that Bengali must be implemented or used everywhere in Bangladesh. So High Court passed an order that everywhere, including government offices and private offices, car number plates, signboards, banners, media advertisements, communications must be in Bangla. So then, actually, what we found that it actually violates the Trademark Act. It actually violates Article 39, which is freedom of expression, which is Article 19 in India, because these trademarks are expressions of this businessman, and it could be in any language. The media communications, the contents that we see in the billboards are all freedom of expressions, and also, to some extent, the trade names, trade marks too. So we actually then appealed against it, and the appellate division stayed the High Court order. And the matter is now pending, is sent back to the High Court for rule hearing. I think 16 January is the date, if I'm not mistaken. So we expect to win this, and
Mishbah,
if not...
I ought to request you.
Sorry. Okay, no, that's the last slide. If not, then we'll get an exception that this order should not be applicable for IPRs. With that note, I'd like to thank, but I'd like to invite you to come and visit Bangladesh. Please do come. It's a great place to do business, and you can now enforce your IP rights too. Thank you.